Good morning and welcome to Archer's webinar this morning in conjunction with CICES. Today we are going to look at security and questioning how secure is your project. Just before we get down to the nitty-gritty, a couple of points. Firstly, a copy of the slides will be sent to all attendees after the webinar, and a recording of this will be added to the CICES YouTube channel. So just before I get started, also, I don't know if, how many of you know us, but we are a firm of solicitors based just outside Colchester in Essex. We are a pure construction practice specialising in contentious and non-contentious construction. We have a headcount of 20 of us, and say we do all sorts of disputes, from final account disputes to time claims, to defect claims, to fire safety claims, anything basically which touches or concerns construction. That is our bag. So what are we going to be dealing with today? Well, here's a summary of the topics we're going to be talking about: bonds, guarantees, collateral warranties, indemnity clauses, escrow accounts, and project bank accounts. For those of you who saw on the slide, my name is Ruth Kavanagh. I'm one of the partners here at Archer, and I will be covering the first three topics, and then my colleague Carolyn Porter, who's also a partner here, will be covering the last three topics on that list. So firstly, without further ado, bonds. What is a bond? Well, a bond is a means of security for non-performance. The issue of a bond undertakes to be responsible for fulfilling obligations owed by one party to the other, and in the event of default, the payment of money. So I'll be looking at two types of bond primarily, which are the on-demand bonds and the conditional bonds. Whilst I'll talk about those further, the on-demand bonds require the issuer to pay in circumstances where the employer makes a compliant written demand. They don't have to commence proceedings or prove breach of contract. That's the whole point, is on demand. Conditional bonds, as the name suggests, make payment by the issuer conditional on an event occurring. That event could be receipt of an adjudication decision or a court judgment. The Association of British Insurers have produced basically a performance guarantee bond. I'll also be looking at some key provisions, and we'll be talking also about the current market. So why use a bond? Well, the reason for a bond all relates to solvency, or should I say insolvency. The bond market, as I say, one of the topics we're going to be talking about is the bond market. It has significantly tightened recently following a number of insolvencies. So what does it provide? Well, it can provide security for an advance payment made by an employer to a contractor, often for things like bespoke manufacturing of products or works. And the employer wants to know that its money is protected in the event of insolvency of the contractor. And the bond typically provides that if, or to the extent the contractor fails to meet his contractual obligations, the issuer will refund the advance payments made by the employer, or the unearned element of the advance payment. Off-site materials, as the name suggests, it is payment for materials which are held off-site. The bond will be for the value of those materials and will reduce in value as the materials are delivered to site if they are delivered in stages. Retention bond, that is in lieu of the employer taking retention from certified sums during the currency of the works. The sum is covered by the retention bond and reflects the sum that the employer would have held as a retention. And just like retention, it usually reduces in amount after practical completion. All of these require the input and the backing of a funder. And as I've said, that is the tricky situation at the moment. The bond market has been tricky because the bond providers are wary as a result of a number of insolvencies recently, and then a number of calls on bonds. So types of bonds, I've already covered a couple of these, but listed on your screen are the types of bonds. I've written on my notes available in inverted commas. As I say, it's only available insofar as you can get somebody to provide you with the bond. Just dealing with on-demand and conditional bonds and what the difference is. So there's primary obligations and secondary obligations. So primary obligation bond, that's an on-demand bond. and it's an undertaking from the bond provider to pay a given sum of money with no reference to the liability of the contractor. So it's on demand. They don't need to prove anything else. You write the demand, it's got to be paid. And then a conditional bond, that's a secondary obligation. So the bond provider's liability to pay is contingent upon breach by the contractor of the underlying contract. You have to prove that breach. You have to establish breach by the contractor. So here on the slide, I've got, again, the on-demand versus conditional. The on-demand is kind of an international performance bond. Retention bonds are on demand. Advance payments are on demand. Off-site materials is on demand. And the conditional bonds are tend to be UK-based performance bonds. I touched a minute ago in the summary on the Association of British Insurers bond, and that has some specific wording in relation to it, and that it is to, as you'll see on the quote, discharge the damages sustained by the employer as established and ascertained pursuant to and in accordance with the provisions or by reference to the contract, and taking into account all sums due or to become due to the contractor. So in that instance, you need to prove loss. You need to prove that those damages have been ascertained. Now, there's reference on your slide to a case called Paravi BV versus General Surety and Guarantee Company Limited. Now, in that case, that concerned a JCT contract, which provided for automatic determination of the contract in the event of insolvency. In this instance, the administrative receiver was appointed, and it was a condition of the bond that the giving party was in default or breach. And in this instance, say the administrative receiver had been appointed. The party had provided a bond to the employer, and as a result of the insolvency, as I say, the contract was automatically terminated, and the employer sought to claim on the bond. Now, in this instance, the court found there was no obligation on the contractor post-automatic termination of the contract to carry out the works. Quite obvious, there's termination, they've got no obligation to continue with the works. And it was condition of the bond that there must be some breach of contract on the part of the contractor. And unfortunately, the court decided here there was no breach following the automatic termination, and the extinguishing of any obligation to complete the works meant there was no breach, and therefore the employer unfortunately had no claim against the surety under the bond. So what are the key provisions? Well, you need, based on that case, you need to consider what is the default. Is it insolvency? How is the insolvency defined? Is the bond on demand? Is there a primary obligation there to pay, notwithstanding you don't need to prove breach, you write the demand, you're entitled to it? Or is it conditional on something happening and have those conditions been satisfied? How much is it for? That might be a really obvious question, but you need to know the value of it to make sure you consider that protects you sufficiently. And when does it expire? And also, what do you need to do prior to that expiry date to make sure that you have a claim remaining under the bond? Now, I've touched on the bond market and the difficulty in the tightening in the bond market at the moment. There is generally considered to be an unavailability at the moment of bonds. And the bond market has been rather scarred recently in relation to some kind of high-profile insolvencies. Henry Construction, I know, is one. Obviously, recent demise of Buckingham Group, that's another. So there are some issues there as regards to the bond market. The higher prices as well for the bonds. We're seeing some unusual provisions. And, where now really are the bonds coming from? I know that people are, on the search, but as you say, the reports that we're getting back is that people are now offering an alternative to a bond by way of a guarantee, which I'm going to talk about shortly. And interestingly, somebody said to me the other day that people always considered that it was a true kind of reflection of that business's strength as to whether or not they could get a bond. But at the moment, I'm not sure that's so sure, because I think there is, I think people are really struggling to get them, no matter their strength or perceived strength. So coming on now to guarantees. What is a guarantee? That's what I'm covering. Key provisions of a guarantee. And then I'm going to be talking about two types of guarantee. So a parent company guarantee and personal guarantees. What is a guarantee? Well, it's a promise to fulfill an obligation if a third party fails to do so. It's a contractual agreement, it's a separate agreement that creates a secondary obligation to support a primary obligation. So key provisions of a guarantee: it must be in writing, it must be signed, and can it be done by email? ? Only to parent company guarantees. This is obviously not funder backed, and a parent company guarantee. So if a party is contracting with a subsidiary and it's got an ultimate parent, often the employer will ask for a parent company guarantee from that ultimate parent. They're going to be interested in looking at the solvency of that parent, because that guarantee is only going to be as good as the solvency of the actual guarantor itself. Slide says, where is the parent based? Is it going to be easy to get to them in the event that the party under the underlying contract defaults? And the key provision here is that the guarantee gives no more than the underlying contract. So any defences that the parties to the underlying contract would have as the payment, for example, the guarantor can run those same defences. So as it says on the slide, the employer may not recover any more under this deed in respect of any matter than the employer would be entitled to recover from the contractor in respect of that matter, net of any set-off. And it says the employer may not start proceedings against the guarantor under this deed in respect of any claim if any proceedings against the contractor in respect of the claim would be statute barred. So what that's saying is that if the original party under the building contract had a limitation defence, then the guarantor is entitled to run the same defence. Personal guarantees. That's a personal promise of an individual to guarantee a company's performance. Again, the effectiveness of this is always going to relate to solvency. What is that person's underlying assets? Are you actually going to be able to get to them in the event that you receive a judgment against that individual and then you seek to enforce it? On the subject of enforceability, you also have to consider whether or not that personal guarantee has been properly executed. You have to consider also that person who is giving the guarantee must receive independent legal advice. If they don't receive the independent legal advice on the personal guarantee, then there's a question mark as regards its validity. Turning now to collateral warranties. What is a collateral warranty? Well, essentially, it's a mini contract that flows from another primary contract and benefits a party who is not one of the original parties to that primary contract, but has an interest in the carrying out of the works. So, for example, a main contractor may be required to provide a collateral warranty in relation to a building contract for the benefit of the person who buys the development from the original developer. The person who's buying that development does not have a contract with that building contractor, but the collateral warranty creates that contract. Now, the judicial definition on the slide comes from a case called Swansea Stadium Management Company, which was a claim for breach of contract for defective works brought by the leaseholder and operator of the Liberty Stadium against both the County of Swansea, who were the freehold owner of the stadium, and the employer under the building contract, and Interserve, who were the main contractor under the contract. The claim by the management company was brought under a collateral warranty, and the key issue to be decided was whether the claim under the collateral warranty was time barred, because the claim had been brought more than 12 years after completion of the works under the building contract, and so the limitation period also applicable to the warranty had expired. In deciding that the claim was, unfortunately for the management company, time barred, the judge confirmed the key point about the collateral warranty is that it is just that, it is collateral, meaning it is dependent on the underlying contract. In this case, the limitation period for the building contract had expired, and so even though the collateral warranty is undated, the limitation period for the warranty had also expired, because the beneficiary of the warranty has equivalent rights as they would under the contract, original building contract, and no more. So how do all of the mini contracts, should I say, fit together? The list set out here is a fairly usual list of parties involved in a construction project, although in certain circumstances there are even more, and some very straightforward projects, there are even less. However, even if the contract is very straightforward, for example, and there are no funders, tenants or purchasers, collateral warranties are still likely to be required because firstly, they're likely to be subcontractors and designers involved who the employer will want the ability to bring a direct claim against. And secondly, the contract will usually allow for future changes where the need for collateral warranties may arise. For example, if the employer decides to sell their property within the limitation period, that buyer of that property will want the ability to be able to bring claims against people who are involved in the project at the outset. So, typical setup. As you can see here, we've done a bit of an organogram here, just showing exactly the typical setup of a project. You've got some consultants who are appointed by the employer. The employer is going to be entering into various contracts with the tenant, the fund, and the purchaser. The employer appoints a contractor under a JCT or NEC contract. The contractor is likely to appoint some sub-consultants in the event there's some contractor's design, or in the event it's a design and build contract. Those consultants that the employer appointed are likely to be novated, and the contractor will appoint a number of subcontractors. As you can see, not all of these parties are contractually linked, which is why I'll discuss shortly why collateral warranties are so important. So the basics of the law is in relation to privity of contract. Only a person who is a party to a contract can sue upon it. But then we have the law of negligence, which doesn't require a contract, but a duty of care owed by one party to another, and allows the party owed the duty to sue the other where that duty has been breached and that breach has caused the loss. So in the absence of a collateral warranty, why can't the law of negligence be used? Well, the answer to that question is unfortunately not. So the question is, why do I not owe a duty of care? This is probably best explained by reference to a car accident. If I drive into your car, possibly likely, but I did it last year, and cause damage to somebody's car, you can bring a claim against me for the damage caused, not because you and I have a contract, but because I owe the other road users a duty of care, and I have breached that duty and caused you losses. You may ask, well, surely construction is the same. A contractor should owe the user of a building a duty of care and be responsible for losses where they've carried out work negligently. But in the ordinary course of events, the answer to that question is no, they do not. Is it basically a fudge? Well, the answer to that question is yes. In relation to property damage, the reason that negligence can't be relied on in the construction context comes down to decisions in two key cases, Annes and Merton Borough and Murphy and Brentwood. Both of them went to the House of Lords, as it was then, now Supreme Court, and both concerned claims against the council in relation to their role as building control inspectors. In Annes, this was a case from 1978 and was brought by some tenants of a block of flats which suffered structural defects due to inadequate foundation depths, which had all been inspected and signed off by Merton Borough Council. The court decided the council owed a duty of care to those tenants that the foundations were the correct depth, and the tenants could therefore bring their claim in negligence. A few years later, in 1991, there was a case of Murphy and Brentwood. The House of Lords explicitly overruled its decision in Annes. The case was very similar in relation to the purchase of a house, which turned out to have defective foundations, and those purchasers suffered losses because they couldn't afford the repairs and ultimately had to sell their house at a loss. They then sought to bring a claim against Brentwood Borough Council in negligence on the basis they should not have signed off the construction of the house. Even though the facts were very similar, as they were in Annes, the court basically said that Annes was a bad decision. And essentially, for policy reasons, they decided that that had opened the floodgates to a number of claims for what they called pure economic loss, and the council were not liable in negligence for the defects in that building. As I say, this was a policy decision. I think their justification was that they had 5 law lords sitting in the Court of Appeal for the Annes case and 7 in the later Murphy case. almost as though they had planned to overrule it, as they'd seen the floodgates open in that kind of, say 12-year, 13-year period. This all sparked the rise of collateral warranties, which create a contractual mechanism by which to bring a claim in the event there is a problem with the building later on. So I talked about the normal setup, which is there. You see it on your screen. Nice solid lines between the consultants, the employer, the contractors, subcontractors. And then I go and do that, which is clutter it with some dotted lines and arrows. Those dotted lines and arrows represent likely collateral warranties which will be requested in kind of standard project. So consultant gives, basically the purchaser receives lots of collateral warranties from anyone that's not got a contract with, same with the fund, same with the tenant, and also the employer. If the contractor goes into insolvency and there is a workmanship defect, if the subcontractors are still around, they've provided that collateral warranty to the employer will turn around to the subcontractor and say, I have a collateral warranty, I'm entitled to bring a claim against you as a result of that contract, and therefore this is my claim, please pay up. Now, when I've just talked about the subcontract, the employer says to the subcontract, I have a contract with you, so please pay up. That collateral warranty is only as good as the underlying contract or appointment. So there's no good receiving a collateral warranty and then looking at the underlying contract and really it's, you know, it's hopeless. It's got lots of limitations of liability in it. All of those would feed through into the collateral warranty. The courts have repeatedly held that the warrantor can be no more liable under the collateral warranty than they were under the original underlying contract. And therefore you need to ensure, as I say, that underlying contract does actually do what you want it to do, and therefore otherwise the warranty is going to be worthless. I will now hand you over to Carolyn, who is going to discuss indemnities.
Thanks, Ruth. So as Ruth said, we're next going to move on to indemnity clauses. So what is an indemnity? The word indemnify literally means to recompense for a loss or liability. And so an indemnity at law is a promise to be responsible for another's loss. Now, unlike a guarantee, an indemnity is a primary obligation given by the indemnifier to the person to be indemnified. So there's no need for a third party to be involved when giving an indemnity. A classic example would be where a contractor may agree to indemnify a developer that if they breach any terms within the building contract, that will be indemnified, and the indemnity itself will be a clause within the underlying building contract. There are effectively three types of indemnity. The first is a debt or no breach indemnity. Second is an insured indemnity. And the third and far most common is a contractual indemnity. You won't necessarily find these three definitions in legal textbooks, but it is probably the easiest way to explain them. And I will go into detail now as to what each type is. So looking firstly at a no breach indemnity or a debt indemnity. There's an example here on the slide of what that might look like. So X will indemnify Y for any losses incurred by Y arising out of sums due to HMRC. Such losses shall be treated as debts. Now the key here is that there is no need for there to be a breach by the indemnifier. There is also no obligation on the indemnified party to mitigate its loss. Rather, there is a straightforward obligation on the indemnifier to make a direct payment to the indemnified for the sum claimed. So there's no need to be in breach because the liability has already been agreed. There's already an agreement to pay all sums, and those sums have already been agreed as being a debt. Now, in the context of construction contracts, these are very rare, and we wouldn't recommend that a contractor ever sign up to a debt indemnity. The second type of indemnity are those that are effectively indemnities to reflect insurance. Now, insurance policies are in their own right policies of indemnity. So if a party gives an indemnity which is covered by its insurance already, then there should not be an issue. Looking at the standard JCT wording on the slide as an example, this clause is an indemnity given by the contractor for any property damage caused by its actions. Now, it's important to note that this clause does not relate to the actual property being worked on. So in effect, it's covering damage to third-party property. And that is what standard public liability or third-party liability policies cover. And so this indemnity should be backed off against a contractor's insurance, and therefore a contractor should be comfortable entering into this type of indemnity. The third and final type of indemnity, which, as I mentioned, is the far more common type to see in construction, are contractual indemnities. With contractual indemnities, you will typically see wording that will say the subcontractor shall indemnify the contractor for any breach of the main contract by the subcontractor, or similar wordings to that effect. And on this slide, there are a couple of examples of contractual indemnities taken from both the JCT and NEC. Now, there is a perceived risk that by giving an indemnity, a party is just offering a blank cheque. However, that is not quite correct. All indemnities, other than no breach indemnities, will cover direct losses, and there has to be a breach. So it's not simply a case that the sum claimed by the indemnified party is required to be paid. Now, the case that is on the screen there, Total Transport Corporation versus Arcadia, is the appropriate authority whereby the court confirmed that the ordinary rule of remoteness applies even in an indemnity provision in the contract. So any losses claimed under an indemnity provision, provided that it is not a no breach indemnity, must have been in the reasonable contemplation of the parties. There is also ordinarily, subject to any words to the contrary, an obligation on the indemnified party to mitigate those losses. Therefore, whilst it does depend on the precise wording of the clause in question, the general stance taken, which tends to be it's an indemnity, we cannot agree to this, has actually come about due to a wider misunderstanding of what a contractual indemnity is. Indemnities are often therefore not as bad for the indemnifier as they may seem, and indeed sometimes not as beneficial for the indemnified as they may appear. So if you do come across a contract that you are being asked to enter into that has indemnity clauses within it, it's important to look at the precise drafting. In the absence of express wording, as I said, the position for an indemnity is not a great deal different to that of normal breach of contract. So when looking at the wording of your precise clause in question, if you are the party being indemnified, it is important to ensure that the indemnity covers all losses. That includes direct, indirect, and consequential, in order to gain the most benefit from the clause. That the clause uses the word indemnity so as to make exactly clear that it is what it is, and that there's no requirement on you expressly to mitigate your loss, and that there is no cap on the liability. Conversely, if you're the party giving the indemnity, you will be looking to limit the scope of any liability. So to do so, you will need to ensure that the indemnity covers direct loss only, ensure that the indemnified party is under a duty to mitigate its losses, and you may also be able to negotiate a cap on your liability under the contract as a whole, or specifically in relation to the indemnity that you are given. So as with all contractual clauses, indemnity clauses should be carefully drafted so it is clear exactly what is being covered. Moving on now to escrow arrangements. So I'm going to look at what are escrow arrangements, why are they used, how do they work, different types of escrow arrangements that are available, and some key issues that may come up when using escrow arrangements. So, what is an escrow arrangement? Effectively, an escrow is a separate pot of money taken away from the employer and put into a ring-fenced account. And then when a trigger event occurs, the contractor can ask the escrow agent to release that amount of money to the contractor from the escrow account. Typically, escrow accounts are used when there is a risk of employer insolvency, such as where an SPV is setting up a project, but this isn't always the case. Also, escrow accounts tend to be more suited to larger projects due to the additional administration and cost involved in setting up the account. But the primary purpose for escrow accounts is ordinarily to protect main contractors. So how does an escrow account work? Well, an agreed sum of money is paid into an interest-bearing account. So that will be expressed as the escrow sum, and it will be paid into the escrow accounts by the employer. The account will be held by the escrow agent. Now, more often than not, an escrow agent will be one of the parties' solicitors, so either the employer's solicitors or the contractor's solicitors. When and if a trigger event occurs, the contractor can make a claim on the escrow sum, and the escrow sum can be paid out to the contractor, and then the escrow sum should be topped back up again to the agreed escrow amount that should remain in the escrow accounts at all times. There are two main types of escrow accounts. The most common type is a one-off security pot. So this is where a smaller amount of money, ordinarily a percentage of the contract sum, is paid into an escrow account, and it is only called upon in the event of a default by the employer. So for example, if an employer does not pay a certified sum or any monies due to the contractor following a court judgment or an adjudicator's decision, the contractor can then take that money from the escrow account, and the employer must top the pot back up. The lesser used type is that of a funding pot. Now, in this instance, the entire contract sum is paid into an escrow account, and each month the certified sums will be paid to the contractor from the escrow account. Ordinarily, it's agreed that this pot will not fall below a certain level, but obviously it's not topped back up to the contract sum at each month. Occasionally, you then get a bespoke combination of a security pot and a funding pot, but this requires quite detailed drafting in order to make that arrangement work. The starting point for escrow agreements is often the City of London Law Society. They have a standard form of escrow agreement which covers the security pot arrangement, which is the most commonly used version. As with all protection mechanisms, it is key to understand what the underlying building contract states in relation to payment. It is vital that the building contract talks to the separate tri-party escrow agreement. So the escrow agreement will be between the employer, the contractor, and the escrow agent to ensure that the payment mechanisms within the underlying building contract work and do not fall foul of the Construction Act. It is also vital that the trigger events are established. Now, as I said, ordinarily trigger events will be events of default for non-payment of notified sum or non-payment of an adjudicator's decision or a court decision. But obviously where a funding pot is being used, a trigger event is simply receipt of either a payment notice or a pay less notice, which triggers then the payment of a certified sum. So looking now in more detail at the City of London Law Society escrow agreement, because this gives you a bit more detail as to what exactly an escrow agreement may provide. So as I said, an escrow account must be an interest-bearing account, and that interest is the employer's. If the employer fails to make payment under a building contract, the contractor has to give 5 business days notice to the employer before calling on the escrow account. If no payment is still received, the contractor provides certain pieces of paper to the escrow agent, which is ordinarily a signed certificate by a director, and then payment will be made within 5 days, unless within the interim period the employer either pays the amount due or obtains an injunction preventing payment being made from the escrow account, which is obviously relatively rare. There's often an obligation to top up the sum in escrow, as I said, and also failure to top up the sum can often equate to a right to the contractor to suspend. So this gives the contractor continuing protection throughout the life of a project, that there is always a sum of money within the escrow accounts from a month-to-month rolling basis. And if it falls below the agreed sum, the contractor can suspend in circumstances where they know some money is already put aside, rather than ordinarily having to suspend whilst they may already be significantly out of pocket. There are also lots of clauses about the escrow agent not being liable. So an escrow agent, as I will touch on shortly, is an independent third party and holds no liability for payment to either party under an escrow account. So what do parties need to be aware of when operating an escrow account? The underlying contract needs to make provision for the escrow account to be used. So as I said, the two contracts need to talk to each other, and it needs to work for the purposes of the Construction Act. The escrow agreement also needs a clear and unambiguous payment mechanism to enable payments to be made from the escrow account. It's important to note that an escrow agent is always independent. So don't think that just because your lawyer is the escrow agent, that no monies will be paid out if you tell your lawyer not to make payment, or vice versa, you will be paid if you tell your lawyer to make payment. Escrow agents have to act strictly in accordance with the escrow agreement, and this takes precedence over any client relationship. Also beware of any long stop dates in the escrow agreement that may kick in before PC occurs, especially where projects have been substantially delayed throughout the course of the works. Finally, it's useful to ensure that the amount of the fund in the escrow is sufficient. So we would always advise that the amount in a security pot is sufficient to cover the maximum exposure for the contractor in any given monthly cycle. So the summary really in relation to escrow accounts is they do work, they can give good protection for contractors, but it's really important that they are set up properly, both within the underlying building contracts and within the escrow agreement itself. Finally, I am just going to take a brief look at project bank accounts. Unlike escrow arrangements, project bank accounts are normally used to protect the supply chain where there is a concern over the main contractor's solvency. So project bank accounts enables the employer to pay the contractor's supply chain directly, which mitigates the risk to both the employer and the supply chain. There are standard forms for project bank accounts that can be used. It is also a relatively straightforward process, albeit can be administration heavy. So what documents are needed to set up a project bank account? As with escrow arrangements, there is a need for a separate agreement in addition to the building contract, and this is known as the project bank account agreement. The project bank account agreement has to be entered into by the employer, the main contractor, and all initial subcontractors. There will also be a need for all of those parties to enter into an additional party deed if any new supply chain member wishes to become part of the project bank accounts agreement. In addition to those agreements, the underlying building contract also has to enable the use of the project bank account. And in this regard, the JCT has a standard set of documents which can be adopted, albeit these need to be tailored to each individual project. The NEC option YUK1 is, in our opinion, far too simplistic, and therefore bespoke amendments are really needed to ensure that a project bank account agreement works with an NEC form of building contract. So how does a project bank account work in practice? Firstly, the parties join up to the project bank account agreement, and all sums due under the main contract are then paid into the project bank account. The project bank account is ordinarily held by solicitors. Banks don't tend to like such accounts. And on a monthly basis, the employer's agent or the QS will certify payments due to the main contractor, and within their valuation, it will specify, as part of that sum due to the main contractor, what parts are due to each subcontractor. The total sum will then be paid into the project bank account, and from that project bank account, each party will be paid directly the amount that has been certified as being due to them. It's obviously quite administrative heavy, so there's a lot of paperwork to be involved, and it requires all parties to be on board. So unlike an escrow account, which is topped up with an agreed sum at the outset, the project bank account is ordinarily used more as a banking facility each month. It doesn't require there to be a sum in the pot at all times, albeit you do occasionally see bespoke amendments to this effect, whereby there has to be a balance kept in the account at all times. Project bank accounts can be expensive to manage and run. However, they are widely supported by the government, and the government has pledged to use them on more schemes following a successful rollout on all national highways projects. And this really came about following the fallout from Carolyn that affected so many supply chain members. So whilst project bank accounts do give some reassurance to supply chain members, it's worth just covering some popular misconceptions. There is still no guarantee of getting paid, even if there is a project bank account in place on a project. So only certified sums have to be paid into the project bank account, and even then, such sums might not be paid in. If there's disputes as regarding main contractor's breach under the main contract, main contractor's insolvency, or liquidated damages payable on a project, it may be that the supply chain gets the position where no monies are even paid into the project bank accounts to subsequently be paid out to them. Therefore, they're only as good as the money being paid in, and they don't get round all the problems that can ordinarily crop up in construction projects. If the project bank account does not hold sufficient sums to pay the whole supply chain in any given month, the sums within the project bank account will be paid out on a pro rata basis. And therefore, the real benefit in project bank accounts are that they do stop all of the money simply being paid to the main contractor and then not flowing to the supply chain. So if money is going in, it is then being distributed fairly. So the risk to the supply chain members is reduced. So that's it from myself. I think Ruth and I were just going to have a quick discussion surrounding some of the things that we have had come across recently.
Yeah, so one of the things we've been asked about is that a lot of questions surrounding notice of intention to appoint an administrator. So we were asked recently, I know, I believe you know that Michael J. Lonsdale recently went into administration. They had filed a notice of intention to appoint an administrator, and really the question that kind of I was mooting was, will that be deemed to be insolvency under a bond or an underlying contract? And I think I know what, well, we've discussed what the answer is.
Yes, we have. Sorry,
it'll depend on the terms, I think is the honest answer.
Yeah, it will ultimately depend on the terms of the underlying building contract as to what trigger constitutes insolvency under that contract, and also whether insolvency itself is deemed to be an event under the bond to which can be called against. We've had a few recent scenarios where main contractors have gone into insolvency, and there's been no doubt that they have been in insolvency as defined under the building contract, but some bonds don't actually provide for insolvency expressly, they just provide for payment on breach. And technically under an unamended JCT, insolvency itself isn't a breach of the contract. So it's worth considering all of these points when drafting both the underlying building contract and also the bond wording that you can get approved from any surety. And we've definitely seen in the market recently more amendments, definitely in JCT, whereby insolvency is expressly listed as an event of default under the building contract, and the standard form kind of ABI bonds that you might get have been amended to add insolvency as an addition, in addition to the standard breaches of a building contract, to kind of cover it off from both angles.
Okay. And then kind of leading on from that, kind of the insolvency and how that works in the bond. One issue is, is if it's a condition of the bond that the party has a court judgment, then what happens if that defaulting party goes into insolvency before the judgment is obtained? Can you still seek one via the courts?
Yeah, I mean, it becomes very difficult, doesn't it? I think you've come across this recently.
Yeah, definitely have.
yeah, it becomes very difficult, and so ideally, you don't want your bond to state that a court judgment needs to be granted.
Yeah, I think there are provisions within the Insolvency Act that enable you to apply to the court for permission in relation to proceedings against an insolvent company, but it is by no means straightforward. One of the things I was talking about earlier as well, in relation to indemnities and guarantees, is if there's a separate time limit for bringing a claim under indemnity as opposed to a guarantee. The answer to that question is yes. So an indemnity is indemnifying for losses that a party suffers. A guarantee is something that sits behind the underlying contract and is only as good as, you can only bring claims in the time period that you would be able to under the original building contract. An indemnity, the time starts to run effectively from the losses, so normally from the demand or from receipt of a judgment. So that is sometimes worth bearing in mind when you're looking around at who you have a claim against and how long you have a claim. Indemnity provisions do carry different time limits for bringing proceedings, and the guarantees do. And it will all, unfortunately, come down to the devil in the detail. I had a case a few years ago where there were some conflicting provisions talking about indemnifying and guaranteeing. We had to try and work out whether, in fact, it was a guarantee or an indemnity. Fortunately for us, the advice came back it's an indemnity, so we were well within time. But yeah, the devil will definitely be in the detail and the drafting. That's probably about all we're going to cover for now. I think, as we said on the invite, bonds and security aren't the most interesting topic, but when it all goes wrong, everyone is scrubbing around looking at bonds and security and what security they have. So, it may not be the most interesting of topics, but hopefully it has been of some interest to you today. And obviously, as with any other webinar that we do, societies, if you have any questions, feel free to contact Heather. We will be making another appearance sometime at the start of next year, diary to still be confirmed, but do keep a lookout. And yeah, thank you very much for listening. We look forward to seeing you again.
Thank you.
Thanks.